Okay, please, the court.
Counsel.
Counsel, officer, sweet Lazaro, ladies and gentlemen of the jury. I want you to know, in starting out, that I stand this morning to speak to you on behalf of a sorrowful and broken man. As even they admit from the start of the case, he intended no harm, much less to kill. He's human like all the rest of us, and his moral weight is heavy. Yet he finds himself sitting here today on trial for murder and assault. Juries don't decide moral responsibility. Now we're here for you to decide if there's also criminal responsibility. Like I told you in the beginning, there are certain things that we're not here to do. We are not here to try to convince you that Mr. Pozo Ilias was in the right. He did things that you can't do. You're not supposed to speed. You're not supposed to drive after drinking. You're supposed to be more careful. What I want to convince you of is that he's not a murderer and not an assaulter. And I think I talked some about that this was a case of degrees. We don't say he didn't drink. I'm going to argue that I don't think he was impaired. I can't say that he didn't speed. I can't say that he wasn't negligent because he failed to exercise the standard of care that a reasonable person would under the circumstances. That's negligence. But that alone is not criminal conduct. That does not make him a murderer, does not make him an assaulter. Other thing I'm not going to try to convince you of is that Brian Hovekamp should be somehow held responsible or blamed or anything like that in this case, because I don't care. It doesn't make any difference to the outcome of this case what was going on in his mind. However, it's important, though, to know what he did in the case, because that does make a difference in the outcome of the case. And that was simply driving a golf cart out into the roadway. I think he did it for reasons most people would have done it. It was a recreation day. It was a sunny afternoon in the middle of the summer. You're out at the place you want to be, maybe your favorite place with your friends. Nothing could be better. It's those times when there's not a care in the world and we all conduct ourselves accordingly, not a care in the world. And these folks had been on this golf cart many, many times, this golf course many, many times before. They were used to it. Nobody had to look where they were going to drive. They knew. But I think that in approaching this, and if you look at the cart path, it goes right out into the street with nothing. And the only thing it's got there are the painted white lines on the street. But you got to keep in mind, whatever signal that gave to the golf cart drivers, whatever people standing on the side of the street right there up close could see, it's not the same thing that drivers down the street would see. Mr. Pozo Ilias could not have seen that until he was at the top of the hill or close to the top of the hill. You're coming up this, I keep calling it a blind, almost like a blind corner. It's not a corner, it's a blind hill, and it's that way from both ways. But like all drivers on the roadway, he can't see that, and we can't realistically expect people on the roadway to see that far away. White lines are for people close up on the ground, standing or in golf carts to see. All he can see is the golf cart sign. And we know that the golf cart sign is not a yield sign or a stop sign. It's an alert. It's a warning. And that alone. But let's talk for a minute about a warning of what? First thing, obvious, golf carts might be around here. That's fair. Certainly, it should tell you that. It might also tell you that when they cross, it might be here. I think that's fair. But it doesn't tell you an important thing of what I think is an unintended setup by the way this road and this path were put together. People in the golf cart driving along either don't think or assume we can go straight across. At least that's what we saw him do. People coming up on the roadway don't know they're supposed to stop or yield. They're just alerted that it might be there. And you've got this situation where that sign doesn't tell him that somebody could dart out in a golf cart. It doesn't tell them that adults might not be paying attention either. Remember, we talked about in the voir dire that the rules for people on vehicles are different than for pedestrians. And the whole idea of a crosswalk, of course, is for pedestrians. And the rules are different. If pedestrians are standing around there, you've got to stop and wait for them. Not the case with golf carts. And I think that's what they're asking you to do here. They're asking you to make his failure to predict and respond to a dart out, which is what this amounts to by a golf cart, makes him a murderer or an assaulter. Now, I'm going to talk about some of the specifics of the evidence because, as I said, this is a case about matters of degree, maybe exaggeration. But I think a good example was Mr. Webb, the school teacher. Now, you're not going to hear me say a bad word about Mr. Webb. He seemed to be an upstanding person, reasonable guy, was nice. I don't think he intended to tell the police something wrong, but he watched what happened, and he did what humans do. We see with our eyes, we hear with our ears, it then goes into the brain, and when it's coming out, it's edited, and it's edited very simply. We divide the scene into good guys and bad guys. Pretty easy to do, even if you're not intending to. And we start attributing good guy things to the good guys. The good guys were careful. The good guys stopped and looked both ways. The bad guys were speeding. The bad guys were trying to run away. All this stuff, and none of it's all correct. But it's what people think there. It's what the brain does, and it separates good guys and bad guys, and I don't think that changed even when the police got there. There's an interesting thing that he said, though. And I think there's plenty of truth in what Mr. Webb told us. And I don't think his brain could have come up with the sound of the car if that didn't really happen. And I think it's fairly important if you look at some of the evidence, and I'm going to talk about the black box in the car in a little bit, and I'm not intending to rely on it a great deal because I don't think you should, but you might. And if that's true, the acceleration of that car was when it was coming up the hill, not necessarily in view, but Mr. Webb, 30 feet back or whatever that was, certainly heard it. So the idea that a car was coming up there was not a shock to anybody. It's the kind of thing you sometimes see if you can just dart across and avoid it, see if you can beat it. I think there's going to be an argument along the lines of Mr. Pozo Ilias drove his car, wasn't his car, it was his friend's car, through a crowded park. I thought I heard that coming from their side a couple times during this case, and I want to stop and say that I think that's a bit of a mischaracterization. You saw the videos from that day and the ones after this. The road that you drive up is not like a subdivision road where there are houses and streets and cars parked along the side. It's in the middle of a park. It's true, and you saw from the videos, there were other golfers around. People were there that day, that's true. But it's not like he drove through a playground with people milling. The golfers, as if you recall, are all divided into small groups of 4 or less and separated by 8 minutes apart across a giant field. It's not the kind of thing that you see the golfers around, they're all going to be away from the road, that clues you in. So I don't think the driving through the crowded park is a fair argument. I want to talk a little about speed, and I want to talk about the computer on the car. We live in an age where if somebody presses a button on a machine and it puts up on a screen, we start believe in it. It just seems to be part of our nature. Whatever a computer says or does, we buy it, hook, line, and sinker. And I want you to be more skeptical here, not just because this is a murder case, but because this is an old car. Forgot it was a 2004 or 2007 Ford Mustang that Officer Gillis, I think, never even saw the computer on it. Nobody's looked at it. Nobody has performed any test on that to see if it was still working properly the day they installed it. Sometimes these things might have to be synced, and I don't know. Okay. Now, there's some things in that black box that help us a little, some things that hurt us a little. It's just hard to go picking and choosing what, because I think it's all a little suspect. It would make sense that he punched the brakes. At some point in time, had to see, and he even said he couldn't stop. It would make sense that he punched the brakes. And the black box does show that he punched them for 1.4 seconds. But they also say that he was going 53 miles an hour and that there's no skid marks there, which I thought was extremely odd and unusual. Well, if you remember, and it only makes common sense, if you're going to try to compute friction between tires and the road, you got to know something about both surfaces, the tires and the road, and they don't know anything about the tires. Nobody looked at them. Nobody knows if they were inflated properly or all the way, if they were worn or not worn. You'll see some pictures of the car in there, but they're not going to tell you anything that you need to know. This kind of a thing could affect this, and as we saw with the math, that works out if somebody's going 40 miles an hour and the tires are worn. You get that number a little bit down, you start getting the same things. And what that tells us is that these have to be taken with a grain of salt. They have to be taken as estimates. And I don't want you to forget, first thing that he started talking about in his broken, hard to understand English is about standard transmission and braking. And I don't know, I've listened to it, I don't know exactly what he said, but I'm not sure those brakes worked on that car, and I don't think they are either. And if there's something with it, they're the ones who have to prove this, not us, not me, not Mr. Pozo Ilias. I want to talk a little bit about right-of-way, and we got a little bit yesterday with some confusion about what a golf cart is, whether it's, and it doesn't make any difference whether it's a motor vehicle or just a vehicle for what I'm going to tell you. Because if it's a motor vehicle or a vehicle, the point is it's not a pedestrian, and it's different. And if you're in a vehicle, which a golf cart is, and you want to enter a roadway, you don't have the right of way. Those white lines don't do that. You have to yield the right of way to oncoming traffic, and you have to be aware to hear and see them. It's no different than pulling out of your driveway into the street where you live. But I bring this up because I'm anticipating an argument that's going to come from the other side. It's one I think I would make if I were them. All that changes, see, and I'm going to call this the first in time rule. If I don't have the right to be in the street, but I'm there so early that everybody sees me in time to stop, that changes things some. Problem with the argument is there are more facts they need to make that argument to a jury in court in a murder case, and that is nobody knows how fast that golf cart was going. We know that they go 10, maybe 12 miles an hour as an estimate, but you don't know how fast it was going. And unless they can prove that the speed got it out there before he got there, that argument doesn't work. We're left with what the law is and what the signs are and what the default is, which that you can't pull out in traffic. People aren't supposed to be held to see dart outs. If it's children, that's different. children are pedestrians. We sort of expect you to see dart outs if they're children, but adults in golf carts, no. So it's all about what we're holding him to see. I'm going to talk a little bit about alcohol. I want you to keep in mind that before they took him to go do any of these field sobriety tests that you watch, he was in this accident where an airbag deployed in his face, blew up in his head. He stood out in the sun or sat in the sun, and they told us they won't let him have anything to drink at all for an hour and a half. 90 degrees in the baking heat. And then they want him to do the field sobriety tests. And Officer Bassler, I looked at those, and I know you did, and my take on them is not the same as his take on them. Not close. After doing all that, I think he expected Mr. Pozo Ilias to be perfect. And humans aren't, and that doesn't mean you're impaired. Another thing we're watching, and all the things he was describing, and you got to look really, really hard to see any of those. The moving a hand, he said, for balance, it's barely noticeable. It's barely short of perfect. I don't know if he was just the same degree of discrimination in looking at Mr. Pozo Ilias' eyes, but we had no ability to see that. I have no ability, and you don't, and they don't, to judge whether that's 45 degrees and it flicks or anything like that. We are left with just his word, and he doesn't see things the way I do. I don't see things the way he does. I did not see the impairment that he described. But then after all that, in another half hour, they take him downtown, and they start taking blood out of him. And Dr. Davis said some things that I thought were important. And some other things I looked in here just to go see after having done a few of these. Alcohol leaves the body mostly through metabolism through the liver. Sweating doesn't do it. And Mr. Pozo Ilias, no doubt, sweated a lot. If you're as drunk as they seem to be saying he was, and you don't ever once go to the bathroom, I just found that odd, and maybe that means he's just sweating unbelievably, and that's where all the liquid's going, all the water's going, because alcohol doesn't go out much through sweat. I also noticed they were all in close contact with him doing those field sobriety tests in the car, and I was listening just to hear what they would say. They were describing the indicators that he was drunk, and nobody said anything about how he smelled. Till later, 2 hours, 3 hours later, Officer Quisenberry, first one in the record that mentioned it. I think that's because he wasn't anywhere near as drunk as they said. I think Dr. Davis arbitrarily estimated that 45-minute to start his timing off. There's no basis for that. And that he wasn't anywhere near that close to where those numbers are. And I think that well, I don't have as much confidence in that, all those tests when they dehydrate him like that. And then after a long while, it finally gets to the point where there's some alcohol coming out and Quisenberry smells it. I think that's significant. I think he was still in whatever phase going up and not down. And I can't say that he wasn't drinking, and I can't make that go away. But those numbers, whatever they are, if they're lower like I think or higher like Dr. Davis said, they don't mean anything without Dr. Davis. And what you've got to do is you've got to look at what you can reliably see to judge his impairment. People speed without being drunk. I don't think speeding's a sign of it. You got to look at the way he acted, look at what he did on the video that you saw, and make your determination. And I don't think it's there. Now I want to talk a little bit about the instructions because they're everything. And if you look at these, the difference between murder, second-degree manslaughter, and not guilty are painfully slim. The negligence, failure to exercise the standard of care a reasonable person would, is not a crime at all. To get to any of them, they've got to get to the definition of wantonly, and I'm going to take a second and read that to you. I know the judge did, and I'll say wantonly when a person acts wantonly with respect to a result or to a circumstance described by a statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. And the rest of it's being intoxicated doesn't help you there, which is understandable. But that's what separates this from negligence. And if you can't find this much beyond a reasonable doubt, we don't get to any criminal conduct here, not wanton endangerment, not assault in the second degree, not manslaughter in the second degree, okay? Where they want you to go is a step beyond that. And that step beyond that is, in each of those, the manslaughter, the murder, the assault first, the wanton endangerment first, engaging in conduct which created grave risk of death to another and thereby caused the death of Chris Schulz under circumstances manifesting an extreme indifference to human life. Okay? It's a lot of words, and well, here's what it's about. I look back and listen back to Mr. James's voir dire, and he had made a really good point in that when he was asking questions about robberies. And the point he was making is there's different ways to commit the same crime. And I think the one, if I remember close enough to correct, I'm not paraphrasing too bad, the one was where he went and committed a robbery by pointing a gun at somebody and demanding their money. And the other one, I think he beat them with a bat and demanded their money. The law recognizes both those things as the same robbery, okay? Same thing. It's because between the act of pointing a gun and beating with the baseball bat, legally, those are equivalent things. They're equal things. If you do one, you're just as bad as the one who did the other. So that's a good point, because when we get to murder and we get to assault in the first degree and wanton endangerment in the first degree, I'll say with the murder and with the assault in the first degree, the law also recognizes two different ways to commit those crimes too. One of them is intent. If you walk up to somebody on the street with that gun and pull the trigger because you need...
You may.
Right, you don't see this very often where a closing is interrupted with this long of a sidebar, but throughout this trial, instead of objecting, both sides have just called sidebars, and they have gone up to complain about the other C.K. Hoffler's watching along with us. And this is tough for the defense, who's rolling along, has a plan, and boom, now it's interrupted. His words to the jury.
Well, I think it's you have to proceed really cautiously. I don't think juries like this kind of interruption, and especially interrupting during closing or opening is a bad move to make for any lawyer. And it's sometimes it's designed to interrupt the flow, but other times it's designed really legitimately to preserve the record. So as a practice, as a trial lawyer, I would rarely, if ever, interrupt the other side during opening or closing. I have to really, really want to make a point. Oh, they're coming back.
Yeah.
Okay.
Okay. When we were talking about robbery, the law recognizes an equivalence between the gun and the baseball bat. When we get to the homicide and the assault, that difference is not an act that you can see, it's in somebody's mental state. We ask you to decide the difference between what's going on inside somebody's mind, inside their heart, what they meant. And what that's intended to be is to be a substitute for, it's a substitute finding for people for intent, is what it is. It's a substitute. I don't think it's a fair substitute in this case. I don't think that his conduct rose to the standard of extreme indifference to the value of human life. I think he was negligent. I understand the argument on the definition of wantonness, but they have to prove that beyond a reasonable doubt too. And with all these instructions, you're going to note that they're, with some of them, with the murder instruction and the manslaughter and the second degree instruction, one's higher than the other. That's called a lesser included instruction. And often it's the case where they prove part of a crime and not all of it. Well, that's what that's for. If they prove part of the murder but not all of it, then that's what goes to the second degree manslaughter. If they prove part of the assault but not all of it, and the part they don't prove is the extreme indifference to human life, then it goes back to the assault second degree. Now, in a few minutes, I want you to read those with a critical eye, because everybody in this country, even if you're not from here, is presumed innocent. Presumed innocent. And that means all those elements are important, and if they don't prove all of them, you can't just fill in. In a few minutes, I'm going to sit down. If I think of something else later, I can't get up and say. If Mr. James makes a point, and he will, I can't get up afterwards. I can't come into the jury room and say, well, what about this? What I want you to do, what I'm asking you to do, though, if there are points that he makes, please be open to the other side that might be there. You're not bound by what we say or what we argue in these. You're your own people, and all 12 decide. But I'll tell you this, if you decide tomorrow, a week later, 2 weeks later, there was something you failed to consider or something you did that you didn't want to, you can't come back and change it either. So I thank you for your attention in the case. I'm going to turn this over to Mr. James, and now we wait.